In M&A transactions, protecting the buyer from post-closing risks is essential. Escrow arrangements and holdbacks are two widely used mechanisms to ensure that sellers fulfill their obligations and that any future claims can be resolved fairly. In Vietnam, these tools must be tailored carefully to align with legal restrictions, banking regulations, and enforceability requirements. In this video, we explain how escrow and holdbacks work in Vietnamese M&A deals and how to structure them effectively. An escrow is a financial arrangement where part of the purchase price is held by a third-party escrow agent, typically a bank or law firm, for a defined period. The funds are only released when specific conditions are met, such as the expiry of a warranty period or resolution of identified risks. In Vietnam, escrow is especially useful when there are concerns about regulatory approvals, tax liabilities, or potential legal disputes. A holdback is a portion of the purchase price that is not paid at closing. Instead, the buyer retains it directly and agrees to release it later if no issues arise. Unlike escrow, a holdback is not placed with a third party but remains under the buyer's control. This gives buyers leverage but can be more contentious in negotiation, as sellers may view it as an unsecured delay in payment. Vietnamese target companies may have risks that are hard to quantify or resolve before closing, such as pending tax inspections, incomplete license renewals, or undocumented liabilities. Escrow and holdbacks allow buyers to close deals while deferring payment until these risks are clarified or expire. They also motivate sellers to cooperate post-closing, such as assisting with license updates or contract novation. An escrow agreement must clearly define the escrow amount, escrow agent, release conditions, holding period, permitted deductions, dispute resolution, and interest allocation. It must be signed by all three parties: buyer, seller, and escrow agent. In Vietnam, only certain banks are legally permitted to act as escrow agents for foreign currency transactions. The escrow agreement should also be bilingual and aligned with the share purchase agreement. Holdbacks are simpler but must still be clearly defined in the share purchase agreement. Specify the amount held back, the conditions for release, the timeline, and what happens if a claim is made. Vietnamese law does not prohibit holdbacks, but enforcement depends on the clarity of the contractual language. Include language allowing offset of claims and define the documentation required to trigger a claim. Typical conditions for release include expiration of warranty periods, issuance of required licenses, clearance from tax authorities, or completion of specific post-closing obligations. Buyers may also use escrow to resolve known risks, such as pending litigation or employee compensation settlements. The release language must be objective and verifiable. Avoid vague conditions that could lead to disputes. Vietnamese banks may require approval to hold foreign funds or may be unwilling to open escrow accounts for M&A unless the parties are local. This creates practical constraints, especially for cross-border transactions. In such cases, parties may opt for offshore escrow arrangements or use law firms in other jurisdictions. Holdbacks are more flexible in this context but come with enforcement risks if poorly drafted. Sellers typically prefer escrow over holdbacks because it provides some neutrality. Buyers prefer holdbacks for control. The size of the escrow or holdback, commonly 5 to 20% of the purchase price, depends on the level of risk, deal value, and negotiation leverage. The duration is usually 12 to 24 months but can be shorter for specific issues. Legal counsel should help balance commercial and legal interests during negotiation. In Vietnam, the timing of tax obligations on the seller may be triggered by signing or payment, depending on the structure. If escrow or holdback is used, careful planning is needed to ensure that the seller is not taxed prematurely on funds not yet received. Consult tax advisors to align payment mechanisms with tax reporting and avoid unexpected assessments. At LTS Law, we help clients evaluate risks, structure escrow or holdback terms, and draft enforceable agreements. We liaise with banks, structure compliant payment flows, and coordinate with tax advisors. Whether acting for buyers or sellers, we ensure that protections are practical, lawful, and aligned with Vietnamese and international standards. If you are entering an M&A deal in Vietnam, don't leave post-closing risks unprotected. Contact LTS Law or visit lts.com.vn to learn how escrow and holdback tools can safeguard your transaction and secure peace of mind.